time for discussion.
Absolutely.
Questions, and Robbie, I'll let you field your own questions. There are two things, practical things I should mention, I guess, real briefly, if I can insert a parenthesis. One is if you need those parking cards, Kevin, where are you now? Yeah, Kevin's got those in the back of the Speedway garage. Get those from him. And also, since we're going to have only a limited amount of time today, we're going to reassemble, those of us here in Austin, on Tuesday at the Eastwoods Room in Union to continue this discussion and conversation, sponsored again by 5-Year Kappa Free Pizza. So that, next Tuesday at noon, Eastwoods Room. But let's go back to the...
Thank you.
From the ridiculous back to Sublime.
Yes, sir.
Yes, you mentioned, of course, judicial supremacy, but couldn't one argue, maybe getting out, that legislative supremacy or legislative activism, executive activism and supremacy is going to be feared more,
Mm-hmm.
especially in today's context. So wasn't Calvin right in his position on government that whichever party is in power will generally tend to be the party that broadly constructs its own sense of power? I guess isn't that more to be feared than the executive branch? I mean, isn't the judicial branch basically the least branch?
No. Of course, Hamilton did make that argument in '78, in Federalist 78, that it would be the least dangerous branch. It doesn't have the power of the purse or the sword. You know, its powers really are powers of persuasion and so forth. And I think that it's probably fair to say that the author of the 13th letter of Brutus, who criticized Hamilton and said that's just not the way it's going to work out, was proven right in that particular debate. That courts have turned out to exercise really quite enormous power, which I think can't be denied. You know, for good or for ill, they did hand down Dred Scott. They did hand down Lochner. They did hand down Brown versus Board. They did hand down Roe versus Wade. Some of those decisions we today condemn. Some of them we applaud. Some of them we're strictly, like Roe, we're absolutely divided about. Half the nation's applauding. Half the nation is condemning. So courts have turned out to be very powerful actors. And, of course, interests coalesce around courts. Notice one thing about courts. To be a judge requires, effectively, minimum of 7 years education and the money to do 7 years education. It virtually ensures that the people exercising the power of the courts, whatever the power is, will be drawn from elite sectors of the culture by and large. So, there is a question about, a very important question about democratic control, given that judges are unelected, federal judges are unelected and electorally unaccountable. Now, should we worry about legislative supremacy? You bet. Should we worry about executive supremacy? Absolutely. Okay. There are arguments to be made against and for supremacy in any of the three branches. But what about the argument that says constitutional supremacy presupposes no supremacy of any branch? That the situation has to remain fluid, that there can never be a final resolution of things such that supremacy is vested in one branch and or the other, and at the end of the day, it falls to the people themselves, informally but working through the political institutions, to resolve the great conflicts that arise between branches on fundamental questions of constitutional interpretation. Now, I'm not, this is not I can't spin out the whole argument for that view, but it's one view that stands as an alternative to not only judicial supremacy, but to legislative and executive supremacy. The other point that is worth repeating is that with respect to the supremacy of the executive or legislative branches, there really is a check in the hands of the people that's quite immediate. You really can throw the rascals out at the next election. They just did it. That is not the case, at least not easily the case, with the courts, which creates a problem that you don't have with executive and legislative supremacy. Now, all that having been said, I'm not denying that there is a good argument for judicial supremacy. Having things settled in a way that the country can live with. Whatever you think of Bush versus Gore, the country seemed to say, we're glad that's settled. There wasn't an uprising. People feared that we were going to end up in a constitutional crisis. Now, there are plenty of intelligent criticism of Bush versus Gore. But in that case, a lot of people wanted judicial supremacy. A lot of people didn't. But in the end, it was accepted by had the people not accepted it, it's hard to tell what exactly would have happened. And of course, often whether you want the courts to have the final say in a particular area or not will be not itself a constitutional judgment, but a prudential judgment. I think a lot of people who were willing to live with Bush versus Gore and even were glad that it got handed down didn't necessarily agree with the decision's content. They were glad that the decision resolved the matter, even if they wished Kerry would have won or wished the court would have decided to permit the recounts in Florida to go forward or what have you. I mean, I didn't run into a lot of people like that in universities, but I ran into a lot of people like that outside of universities. They just wanted, they did not want a situation in which it was unclear how the presidency, how this thing was going to end, and where people could even, fear, gosh, is it going to be a military, because the military going to install the president? Or are we going to be like a country in which things like that happen? So I think people were thinking, well, look, as a prudential matter, it's just important that the court resolve this. Here's the decision that they made. We're going to live with it. But come back at me.
Well, I mean, in fact, you mentioned this before, but isn't it true that almost every single justice voted partisanly, with maybe the exception of Stevens? I believe it was 7-2 to final Bush Gore. And that was, I just remember reading, I don't know that case very well, but I mean, isn't that of some concern that almost every single justice voted? I mean, Scalia, Thomas, they all voted, Rehnquist, so on and so forth. They all voted the Republican position, which basically said stop the recount. So, I mean, and that's, I guess I'm arguing that the judiciary there is some check. I mean, they are appointed, obviously. Yes, I mean, you mentioned that they're somewhat insulated, but, you can impeach them. Congress has the constitutional power to really limit their jurisdiction on many cases. So,
well, that's an interesting question, whether Congress in fact has that power. Congress did exercise it on one occasion after the Civil War. It seems to be a power that Congress has in Article 3, and the court was willing to accept that on that occasion. It's not at all clear to me that if the case would go back today to the court, whether it would accept that power of Congress to restrict its jurisdiction, at least the way Congress has considered restricting it, where you take an entire issue, abortion or marriage or what have you, off the judicial table by way of the restriction on jurisdiction. On Bush versus Gore again, there was, at the end of the day, a 5-4 decision. What was 7-2, as I recall, was the question of whether there was an equal protection violation in the method of recounts in Florida, which were variable across the different jurisdictions. And even there, I don't think it was a straight partisan vote. I think Justice Breyer was among the 7. On the 5-4, Souter and Stevens, 2 Republican appointees, joined the 2 Democrat appointees, Ginsburg and Breyer, on the question of the remedy. 7-2, there's a constitutional violation. 5-4, on what the remedy is, are we going to stop the recounts or not? If you really are hostile to Bush versus Gore, and you really think that that is a profound usurpation of power, where the courts are really sort of taking control of the country, they're appointing the president instead of the president appointing them, it seems to me that that ought to make you very worried about judicial supremacy. I mean, especially if you see this not simply as a kind of prudential judgment in a time of crisis, but as a real power grab by the Supreme Court of the United States. That should make you worry more, not less, about judicial supremacy, so that that kind of thing won't be permitted to happen again. Yep. Yep.
Today it seems that congressmen are continuously running for office and raising money because over the years the cost of running campaigns has cost so much money. It seems that it is a benefit in the fact that federal judges are appointed for life and that they are supposedly insulated from having to raise money and having to go before the electorate every 2 years or every 4 years or whatever. So it seems like that would be a benefit in that they would be less influenced by special interests than the legislature, which seems to be at this time is so influenced because it requires so much money to stay in office.
Well, at the end of the day, yeah, I mean, Churchill was right. Democracy is the worst system except for all the others. And at the end of the day, you got to decide whether you want the country to be run democratically, even with the flaws that are created by things like the influence of money and the fact that there are special interests and lobbyists and so forth and so on. And, you know, there might be ways that we can reform and do better in those areas, but there's no way to make it perfect or even close to perfect. Money is always going to have influence in politics. Special interests are always going to have influence in politics. And then the question is that system with all its flaws, the democratic way of governing ourselves, better with all its flaws than a different system, a system in which power is in the hands of a few people drawn from an elite sector of the
Yeah, I mean, there's no question that those what we see in other countries, like our friend in Venezuela now, who's declaring himself king, is a situation where the people are virtually out of touch with their government.
One of Felix Frankfurter's most vilified opinions, I mean, this is one that has marred him forever, was his opinion in the second flag salute. These were cases in the 1940s, and I think the first one was in 1940 and the second one 1943, in which some Jehovah's Witnesses students who refused to salute the flag because their religion forbade that, it interpreted it as a kind of form of idol worship, were expelled from school, where they told, well, either salute the flag or you're out. You go to private school or something, but you can't go to school here. And in the first case, which was called Minersville School District of Pennsylvania versus Gobitis, the court ruled that the school board was within its rights in holding that. And then 3 years later, the court reversed itself in a case called West Virginia versus Barnett, my home state of West Virginia. The court reversed itself and said, well, no, as a matter of fact, this is a violation of the students' constitutional rights. And that second opinion seemed to be a great blow for civil liberties. And yeah, I think it was a great blow for civil liberties. And I actually think it was the right decision in the end. But Frankfurter was in the dissent. He wrote the first opinion, and he was in the dissent in the second opinion. And the dissent is vilified because he's seen as this ogre who was willing to see those kids thrown out of school because they wouldn't salute the flag, and gosh, this is a free country, and that's a monstrous thing to do.
It gets into burning of flags.
This is a predecessor to the flag burning. Well, nevertheless, I would urge you to have a look at that opinion. It's well worth reading. Not only is it a literary masterpiece, it's a beautifully written opinion. For all the vilification it suffered, it's a beautifully written opinion. It begins by saying, as a member of the most persecuted minority in history, I am not insensible to the claims of civil liberties. And he goes on to lay out his case. And one of the points he makes, and I think is so important, and I think we should all agree with this point, even if we disagree with the opinion, the judgment, is that we have to be worried that accepting the idea that the Constitution is for judges and that they always get the final word, and that congressmen don't have to worry about it, and that executives don't have to worry about it, citizens don't have to worry about it, and the courts have the final say, has an enervating effect on ourselves as citizens. It tends to infantilize us in democratic citizenship by leading us to think that on the big and important questions, the big moral question, the questions of rights and liberties, we can't govern ourselves, and we don't have to govern ourselves. There are our betters who know more, who we can trust with that to keep us and the politicians in line. In effect, what Frankfurter was saying is that's bad civic education, and it is undermining the quality of the character of citizens that we really need to have so that citizens will be the protectors of their own liberties. They have to be allowed sometimes to make mistakes if they're really to take on the task of deliberating about big questions of liberty, of rights, and becoming protectors of their rights. And there have been moments when the people have certainly risen to the occasion and even outdone the judges. Yeah, ma'am. Mm-hmm.
Right leads into what I've been worried about. The people, in what you were saying then, would become their own protectors through electing new people to Congress and a new president who then, or a new party who might appoint new judges, and that goes on and on. I have always believed what you were saying, that the Constitution is the overriding principle. It is, as far as I know, other than amendments, is immutable. And the amendments have been accepted by the majority of the people. So that's another way in which we become our own protectors. But I have some concerns. It seems to me, okay, I didn't know the Dred Scott stuff. I mean, I read about it in school, but I didn't know what you told us about, or the Lincoln things. But it concerns me a little bit that the Supreme Court can reverse itself, and yet I know it's done that many times. It smacks to me a little bit of this moral relativity. I mean, if the Constitution is there, and I come back to Roe versus Wade, because that was, well, and even Dred Scott, and then Brown versus the board. If they reverse those, that's going to take us back to the Stone Age. I mean, if it were ever to happen, my husband says, that's never going to happen. That's never going to happen. Well, I don't think
You tell her that?
Oh, he does.
Well, because
versus
what you
Wade.
said was 50%, 50%.
Oh, yeah. Okay. Yeah. I mean, there's obviously a big dispute about abortion. I mean, some people think that if we make abortion illegal again, that takes us back to the Stone Age. Other people, equally intelligent and well-intentioned and good, think that if we reverse Roe versus Wade, we'll be striking a great blow for the sanctity of human life. So, our citizens are divided on this question. Now, the real question is, here, does the Constitution resolve that?
Or should it be a state?
Or a state, or it could be a national. Should it be a legislative rather than judicial? There's two questions. One, should it be state rather than federal if it's legislative? But before you get to that question, you have to know whether it should be resolved by the judiciary as it was in the United States, as it was in Germany, although they came to totally different, opposite conclusions, or whether it should be resolved by the legislature, as it was in Britain, as it was in France, as it was in Italy, as it was in Sweden, and so forth. Okay, so that's the question there. Now, one point that seems to me often overlooked and very important to make is that it's a mistake to assume that if a question is a big moral question, and if the question can be framed in terms of rights, then our Constitution, because it's so wonderful and so comprehensive and so great, must solve it. And then the question is, how does it solve it? And then somebody who's got authority to interpret the Constitution tells us the answer. It's like going to the oracle for the answer. I really think that's a bad mistake. My friend and former colleague Jeremy Waldron has pressed this point very hard, and he's absolutely right. The Constitution does resolve some big important moral questions that have been debated throughout history about human liberty and human rights and so forth. But it leaves many such questions unresolved. And it's no less great and no less dignified and no less worthy of praise for that. And what it doesn't resolve, it leaves to the ordered processes of Republican government whose institutions it specifies to resolve the question. And that's when we have to step forward as democratic citizens, doing our part in the debate to try to make sure that the resolution is the right one. And now we're going to disagree. I mean, in the one point I agree with in the work of the late John Rawls is what he calls the principle of his great political theorist at Harvard who died recently. Jeff, help me. No, the principle of that, well, here, I'll tell you what the principle holds, and I forget the name of the principle, that in circumstances of religious and political freedom, it is natural and to be expected that people will come to different opinions. It's like a principle of rational diversity or something like that. I think that's right. This has been our experience. Where political and religious freedom have been respected, we don't get uniformity of opinion, even on important moral questions, which means that we have to work through the processes that we do agree on, that we do have consensus on, that are established in the Constitution. Those processes enable us to deliberate and decide without resorting to the force of arms questions on which reasonable people disagree, well-informed people, well-meaning good people disagree, and where their disagreement is not about what Waldron calls the trivia and ephemera of life, but really big important things that have to do, that can be put in terms of rights and liberties. And it's tough. I mean, it is tough. Being a democratic citizen is tough. Living in a democracy is tough because sometimes you lose. And you can lose on things that strike you as very important and matters of fundamental human rights. Now, you can comfort yourself in a democracy by thinking, it's never finally settled. We can always live to fight another day. We can always come back. We can always try again to persuade our fellow citizens that they made the wrong decision and they need to reverse that decision. I don't think, just a final point on your question, I don't think we have to worry much about reversing ourselves, whether it's the Supreme Court reversing itself, which it's done more than 200 times in our history, or are reversing our positions through democratic procedures. I don't think we have to worry that that will lead us to embrace a kind of moral relativism. I think anybody who is morally serious and realizes that we're fallen creatures who can make mistakes will realize that there always has to be some openness for the possibility of correcting an error. It's not moral relativism to think that. It's just a realistic assessment of our own fallibility.
I'm thinking in terms of attitudes changing from one generation to the next.
Plainly they do.
Sometimes I think in terms of black and white. That doesn't fit.
Okay. You, sir.
Professor George, you are making a cogent and compelling case for getting back to the title for civic education and academia. You mentioned challenges. I'm an engineer by training. What are the top three that come to mind? And is the program you are running, and Professor Kuhn's and in some other isolated spots in the country, are you lonely voices crying of the wilderness, or do you have acclamation? Is the time right? Is it too early? Is it too late? Don't forget that the difference between fool and pioneer is only time.
Okay. It's very good to have an engineer. I make sure and have one in each of my audiences for this purpose, and thank you for coming. Well, the Carnegie Endowment for Teaching, which is completely non-partisan, do-gooder academic foundation, issued a report in 2005, Rob will remember, in which it rang the alarm bell. And it said, it's not too late, but it's almost too late. Because students just don't understand the principles of Republican government as we have them here in the United States. And something has to be done about this at the college university level. Civics cannot just be a high school subject. You don't have to call it civics. You can call it constitutional interpretation. You can call it civil liberty. You can call it, it's a lot of different things. But it needs to be done at the college level. And I think that the message is getting through. I think that there are a lot of people, professors at various institutions, who have taken this to heart, many of whom were already doing work in the area, and many more of whom realize that this is something that now it's very important for us to do. I think it took a kind of nonpartisan organization like the Carnegie Endowment to get at least some people to think that we really do have a problem. I mean, half the battle in life, I find, is recognizing the problem. I mean, as long as you're denying that there's a problem there, nothing gets fixed.
Society accept it as a problem.
Or have even the family, right? I mean, if the father of the house, has an alcohol problem, very often the specialists tell us getting the problem dealt with is being impeded because everyone's pretending there's not a problem. I think it happens all through life. And this was a time in which there was a problem. Now, despite the Carnegie Endowment's very salutary report, There does tend to be in the academy, and we could go into the reasons, good and bad, why this is the case, some tendency to identify this cause with conservatism. And perhaps you've noticed that conservatism in the academy is not in the dominant position right now. Yeah, that's right. And that really is unfortunate, because this is not a partisan liberal conservative thing. I mean, the lecture I gave could have been given by a liberal. I'm not. I'm a conservative. Lecture could have been given by a liberal. He might have disagreed on certain points. He might have given a defense of the living Constitution, but that's fine. Just he could use my examples and illustrate my examples just by giving the other side.
You're the Princeton conservative?
I'm yeah, that's right. Yeah, since Jeffy Toulis left us, I'm all by myself. Yeah, they allow one. They allow one. My colleague at Amherst College, Hadley Arcus, says that there's a reason we're not allowed to have two. If you have two, then we'll have them surrounded. So you're only allowed to have one. So I think we need to break through. We need to overcome this idea that to worry about this problem of civic education and to propose the kind of study and the promotion of the kind of study that I'm talking about today is a conservative thing. If we can get past that, I think it will be a big plus. So I want to encourage those in the audience who are liberals to get with the cause here and get on board, and it's proved that this is truly a nonpartisan undertaking.
Well, you effectively enunciate a categorical imperative.
Yes, that's right.
Try to depoliticize it.
Although it's hard. It's hard to depoliticize it in a way because it's about politics. You know, it's about fundamental issues of political theory, and they're beautiful in the Greek. Exactly. You say you're an engineer.
Yes.
You're sounding like Professor Pangl here. It's a very well read. Good. Yes, ma'am.
I'm curious. How you articulated the problem and what the solution is. And you're saying now to say everyone, often conservative people will say, "Oh, we want smaller government," and you say, "Oh, that really doesn't mean they want." You know, they can't keep government to the side, shift funding into different programs, or do this or that or the other. And so this crisis that you see with judicial supremacy, how do you see this being solved? Is it in that Article 3 or whatever?
Oh.
How do we need to remedy this situation here?
Okay. And when your question began, I thought you were talking about the crisis in civic education. No, you're talking about, okay, you're talking about one of the examples that I used, the judicial supremacy. Can I answer the question I thought you were asking, and then I promise I'll answer the second. I do think that it's very important to promote initiatives like the program that Professor Coons is actively involved in and leading here in Western Civilization and American Principles, like my program at Princeton called the Madison program, like the new Alexander Hamilton program at NYU. It's very important for those to spread, for that good news to spread. And also, just in the regular departments of history and political science, we need to attend to these subjects. The last I heard, I hope this is what I heard is wrong, but the last I've heard, Princeton, my own university, has not replaced either Professor McPherson, our great Civil War historian, with a Civil War historian, or hired someone to teach the American founding, the history of the American founding. So even in this area, you have two crucial parts of American history that absolutely need to be covered. And a university, as great we like to think as Princeton University, at the moment doesn't seem to have them covered or doesn't seem to be making an effort. Now, I hope I'm wrong about that and that I'm just misinformed. But I wouldn't be surprised if I'm not, because that kind of thing does happen today. So even in the standard departments of history and political science and so forth, there needs to be a renewal of effort to offer courses, to hire people who can teach the courses, to get some real attention to civic education. Now, on the actual question you asked, judicial supremacy and the problem of judicial usurpation. Part of this problem, I think, is human nature being what it is, as described in Federalist 10. It tends to be a question of whose ox is being gored. Everyone notices the problem with judicial supremacy and or judicial usurpation when they are on the losing end of a Supreme Court decision. Okay? Liberals discovered it when Bush versus Gore was handed down. Conservatives discovered it earlier with the school prayer decisions in Griswold versus Connecticut and some of those early Warren Court decisions. There was this is not a liberal versus conservative thing. There was a time in our history, which I gave you a brief summation of in my prepared remarks, when the judicial activists were on the liberal side, were on the conservative side, and the progressives, the liberals of the day, were their critics. That's the so-called Lochner era from 1905 to 1937, when a conservative Supreme Court was striking down social welfare and worker protection legislation in the name of an unwritten right to freedom of contract in the 14th Amendment, right where a later court in abortion would find the right to abortion in Roe versus Wade, an unwritten right to abortion in the 14th Amendment. There's even a name for the doctrine by which the court attempts to justify itself in these areas, both the conservative court of 1905 and the liberal court of 1973. It's called substantive due process, reading the due process clause as having substantive content which is provided by, in the end, by the judges themselves and not out of the text or original understanding or logic or structure of the Constitution. Now, okay, what do we do about that? Well, we're sort of living at something of a time of transition because the Supreme Court of the United States has gradually moved from a more liberal court to a more conservative court. Now, where that will settle for the next period of time probably depends on the next presidential election. But this is a good time, I think, for people to be thinking, since nobody knows from day to day whether his side or the other side is going to be the beneficiary of judicial supremacy. It's a good time for us to be thinking about what we want the courts to do, because anybody's ox can be gored right now. So now's the time to think about whether you think the question of whether there should be a minimum wage or rent control or abortion or same-sex marriage should be in the hands of the elected representatives of the people or the judiciary. Good time to think about that. Because either ox could be gored right now. We don't have a liberal court and we don't have a conservative court. We have a somewhat unpredictable court because there's a swing voter named Anthony Kennedy who can go one way in one set of cases and another way in another set of cases. So good time to be thinking about it. My own view is that we're right, that the right thing to do, we have been right, I guess by we I mean conservative Republicans, so I should just say me, to focus on judicial selection, to try to find judges who will respect the scope and limits of their own power and not adopt a living constitution view, so-called, which essentially gives them unchecked or unconstrained power. Now, of course, the Republicans have had a very hard time actually getting such people onto the court. And even when they do get them on the court, in some cases they're accused of being unfaithful to their principles of judicial restraint. So, for example, Justice Scalia will be attacked as a hypocrite because while he proclaims a doctrine of judicial restraint, he's voted to invalidate a number of pieces of federal legislation on states' rights grounds, on federalism grounds, and that, his liberal critics say, is a form of judicial activism. Actually, I think Scalia's positions on those issues are quite defensible, but be that as it may, I do think that the conservative side has been right to focus not on getting judges who will rule in a conservative way, but on getting judges who will rule in accordance with the text and the logic and the original understanding and the structure of the Constitution, and not adopt a view of their own power that's so broad as to be effectively turning the court into a standing constitutional convention. Now, sometimes conservatives are going to pay a price for that. The case I love to use to illustrate this is the punitive damages case. And the reason I like to use it is it was a case that I was involved in at the margins and was very badly trounced in. Our firm represented a company that misbehaved in my home state of West Virginia and cheated a couple of local landowners. Cheated is putting it strongly. Their business practices were harsh, resulting in a loss to a couple of local landowners in Wyoming County, West Virginia, of $18,000. A jury of the peers of the local landowners deliberated the case, and they decided that the company was, in fact, liable for this $18,000 in compensatory damages, And so they made an $18,000 compensatory award, plus because they thought that this company, big out-of-state company, should be taught a lesson, they imposed punitive damages of $10 million. $18,000 compensatory award, $10 million punitive award. Well, the company came to us. We said, yeah, we're happy to represent you in this. It seems to us that this is an outrage. We will argue that your constitutional rights have been violated by West Virginia's law, which permits a jury to exercise unfettered discretion as to punitive damages. Such a law is a violation of the Due Process Clause, and it's a violation of the excessive fines clause of the Eighth Amendment. Now, most people don't know it's there. Everyone thinks of the Eighth Amendment as a ban on cruel and unusual punishments, but after you read that part, if you read on in sentence, or excessive fines. And we thought, oh, punitive damages, $10 million on an $18,000 compensatory award. That is an excessive fine if ever I saw one, and so forth and so on. Well, we go into court, and we got amicus briefs from the Chamber of Commerce and every other business group that said that unfettered, outrageous jury awards are ruining the American economy and all this. And we were feeling pretty good. And we were starting to count up the votes, and we said, oh, yeah, well, okay, Rehnquist, he'll vote with us. O'Connor, she's a pro-business judge, she'll vote with us. Scalia, my goodness, he's conservative, he'll vote with us. Thomas wasn't on the court yet. This was the early 90s, I don't think. Anyway, we were doing the counting and counting up the votes, and we were thinking we're sitting pretty. Well, we go in. The thing gets appealed all the way up to the Supreme Court. In fact, the Supreme Court takes the case, which is unusual in itself. And we lose. And Justice Scalia writes an opinion saying, because our first argument had actually been the excessive fines argument, which we really thought was good. And Justice Scalia says, well, look, I looked at the history of the excessive fines clause, looked at it in its textual context as well as its historical context. I agree that this is from an economic point of view, and Scalia's done a lot of training in economics. He said, from an economic point of view, allowing jury awards of this sort is goofy and destructive. And if the West Virginia state legislature had any sense at all, it would change the law and put restrictions on what discretion juries can exercise on punitive damages. But, having said all that, there is nothing in the history or original understanding of the clause or the logic of the actual textual provision or its placement in the Constitution, the structure, which warrants the claim that a legislature cannot constitutionally permit this kind of jury discretion. You lose. So we lost. But, he said, I won't opine on a very interesting question because it's not before us, and that is the question whether the Due Process Clause might include some feature, given its history and so forth, that would be violated by unlimited punitive damages like this. Well, we all took our cue. And so people found a plaintiff real fast who'd gotten a bad judgment, like our client's judgment, and they went back up to the court. We weren't involved in the case this time. But another lawyer was, and he interpreted Scalia as inviting him to, here's the right answer, right? It goes all the way to the Supreme Court. The Supreme Court takes it again. I think it was called Pacific Mutual Life versus Cleopatra Haslip. That was what it was, Cleopatra Haslip. And not only do we lose, with only Justice O'Connor voting for our constitutional claim, so it is 8-1, Scalia writes a scorcher. I'm glad we weren't the lawyers in the case, because our client would have sued us for malpractice just on the basis of this opinion. In effect saying, this isn't just a bad historical argument. This is no historical argument at all. There's absolutely no evidence, no basis at all in the Due Process Clause for constitutional restrictions on punitive damages. Now, that is a case of a justice being faithful to his constitutional principles, his principles of constitutional interpretation, over his political views. There's no question about how Scalia votes on this in a legislature. In a heartbeat, he would vote for severe limits on punitive damages because, as a matter of economic rationality, he thinks giving unlimited discretion to jurors to award punitive damages is crazy. But because he was interpreting the Constitution in a principled way. You might agree or disagree with his principles, and I think they're too narrow or what have you. But nevertheless, because he was interpreting it in a principled way, he voted the opposite of how he would have voted in the legislature. So I think it's very important to do that. Now, the trouble is, I think, that on the other side of the ledger, on the liberal side of the ledger, there is a commitment to the idea that a good judge is a judge who does not interpret the Constitution in a crabbed, constrained, narrowing, rigid way, and that it is in fact the role of the judge to go beyond the text and logic and structure and original understanding of the Constitution in order to confer a broader meaning, more protective of liberty and rights on the Constitution. The best articulation of this, the most compelling articulation perhaps, is Ronald Dworkin's article called The Moral Reading of the Constitution, where he lays out the case for judges to interpret what he calls the majestic generalities of the Constitution, free speech, equal protection, due process, to interpret these majestic generalities as kind of invitations for the interpreter, which happens, of course, to be the courts, to invest them with meaning by a process that is somewhat constrained, but nevertheless includes just reflection on moral right and wrong, justice and injustice. Yeah, so which I think means, since that is the dominant position on, it's not always been the case. Liberals haven't always thought that way. They were on the other side of the divide in the progressive period. But since it is the case now, I suspect that if there is a liberal president, that president will appoint justices having the other point of view. In which case, if rulings come down that are like Roe versus Wade, it will be up to the people to resist. And that resistance could take the form of a constitutional amendment if it's an issue on which there's sufficient public support to get over the huge hurdles, the very difficult process of getting a constitutional amendment through. I mean, it could happen, for example, on the marriage issue or something like that. But I think that something along those lines, some very palpable expression of public dissatisfaction with the court to the extent of actually trying to act against the decision by, for example, amending the Constitution, would be the only thing that could have the effect of sending the message to the judges that they're not supposed to govern the country, they're supposed to interpret the Constitution. Sorry for that long-winded answer. Did I answer, though?
Yeah, I think I was curious if you were just recommending necessarily a curtailing of governmental power back to the level of slavery, because that's a very that's what I was curious getting at. And I think you did too.
Yeah, I don't think that the court should be hugely active in that task of limiting government. I do think government has become too big and too bureaucratic. I do agree with that. But I think that the courts would get themselves involved in usurpations, even in my cause, if they were too aggressive in trying to play a role in scaling back the size of government. I should also add that there have been proposals, floated that I just don't think, in the end, make any sense for dealing with the problem of too aggressive a judiciary. One of them, for example, is requiring that all Supreme Court decisions be unanimous if they strike down laws or strike down federal laws. Or Judge Bork floated a proposal a few years ago saying that where a law, or maybe a federal law, or maybe any law, state or federal, was struck down by the court, the court's decision could be overridden by a 3/5 vote in Congress. Do you remember that? It was something like that a few years ago. And I don't think that works either. As a matter of fact, one jurisdiction, Canada, has experimented with that. Tom might remember this. Is it just one of the provinces, or is it the whole national government? One or the other has a 3/5 provision permitting a Supreme Court decision of the province or of the country to be overturned by a 3/5 majority in the legislative house. And what it turns out is that they just won't, the legislators won't act on the power. They just won't exercise it.
Oh. We have to stop at some point. And again, reminding you, next Tuesday, noon in the Union Eastwood Room, we can continue this discussion. We'll be there, and so will the private campus students and the people that are interested in this. So let's thank you.
Thank you all. Thank you.
Thank you. Start the count again.